She built her fence on my land, so I made her backyard completely useless. I walked outside one Tuesday morning to find a 6-foot cedar fence cutting straight through my backyard, planted 2 feet inside my property line, freshly stained, with a little HOA plaque bolted to the post like a trophy. Sandra Kowalski, HOA president, had done this while I was at work. My garden, 12 raised beds I'd spent 3 years building, the strawberry runners, the irrigation lines, the stone path my late father helped me lay. All of it was now on Sandra's side of that fence. She stood on her porch watching me with her coffee, smiling like she'd won something. I called the HOA emergency line. The man who answered said, "Mrs. Kowalski authorized the community beautification fence project." I asked why it was on my land. He said, "Ma'am, she is the community." That was the moment I decided I was going to dismantle everything she'd built. Legally, patiently, and completely. My name is Marichin. I'm 38 years old, a civil engineer for the County Water District, and I've lived at 14 Birchwood Court in the Elm Grove HOA community in suburban Ohio for 6 years. I bought this house because of the yard, a 1/4 acre, flat, with southern exposure and good drainage. I live here with my daughter Lily, who is 9, and our rescue beagle named Walter. My neighbor to the left is a retired schoolteacher named Frank who grows tomatoes and waves every morning. My neighbor to the right is Sandra Kowalski, HOA president for 7 consecutive years, who has never once waved. I work long hours, 50, sometimes 60 a week. I come home, I cook dinner, I help Lily with homework, I water my garden on weekends. My life is not dramatic, or it wasn't until I found a fence where my strawberry beds used to be. Sandra Kowalski has been president of the Elm Grove HOA since 2017. She ran unopposed the first 3 times because no one wanted the job. By the 4th election, no one ran against her because they'd learned what happened to people who tried. The Elm Grove HOA has 47 homes. The CC and RS are 42 pages long. Sandra knows every line by memory. She uses that document the way some people use a weapon, selectively, strategically, and always in her favor. I first met Sandra 4 days after I moved in. She knocked on my door holding a printed copy of the CC and RS and a highlighter. She said she just wanted to make sure I started off on the right foot. She had highlighted section 4.7, exterior paint must be approved, in neon yellow. I thanked her and closed the door. Within the week, I received my first HOA violation notice. My moving boxes, broken down and stacked on the side of the house, were deemed unsightly exterior refuse under section 6.2. I'd owned the house for 11 days. Over the next 2 years, I received 19 violation notices. My garden hose reel was non-compliant hardware. My daughter's sidewalk chalk art was unauthorized surface modification. My wind chimes were prohibited auditory nuisance. Every single one was signed, Sandra M. Kowalski, president. I appealed 3 of them. Each appeal was heard at the monthly HOA board meeting, which Sandra ran, moderated, and voted in. The board consisted of Sandra and 2 people she'd appointed herself, her friend Deborah Holloway and a man named Phil who I'd never seen attend a meeting in person. I lost all 3 appeals. I paid the fines. I took down the wind chimes. I moved the hose reel to the garage. I told myself it wasn't worth the fight. I had a kid, a full-time job, and a mortgage. Sandra Kowalski was just background noise. What I didn't know then, what I wouldn't find out until much later, was that Sandra had been quietly altering the HOA's enforcement records, flagging certain properties repeatedly to drive down their desirability scores in the community management software. Mine was one of them. The community management software, called Community Link, tracked violation history, payment records, and what Sandra called property harmony scores. She'd pitched this system to the board in 2019 as a transparency tool. In reality, she was the only one with full admin access. Sandra's house at 15 Birchwood Court was immaculate. White siding, black shutters, a perfectly symmetrical boxwood hedge, and a flagpole with an American flag that she raised and lowered on a schedule. She won the HOA's annual Property Pride Award every single year. She voted on it herself. Her backyard, however, was her weakness. It backed up against mine along a shared property line, and it was narrow, maybe 30 feet wide at its deepest. She had a patio, some outdoor furniture, and a gas grill she never used, but the space felt tight and she'd always resented it. I know this because her previous neighbor, a woman named Gloria, told me at the block party in 2021. Gloria had sold and moved away, partly because Sandra had made her life miserable about her vegetable garden. She hated that Gloria's yard was bigger, Gloria's friend said. Sandra's obsessed with space. My lot is a corner lot. It's wider than most on the street by about 18 feet. That extra width is what drew me to the house. I'd measured the property lines myself before buying, using the plat map from the county recorder's office. I am an engineer. I measure things. After Gloria left, Sandra's attention shifted fully to me. The violation notices intensified. She began showing up to my driveway when I pulled in from work, clipboard in hand, listing perceived infractions in real time. I started parking in the garage to avoid her. In spring of 2022, Sandra proposed a new HOA initiative called the Boundary Beautification Project. The idea was to install matching cedar privacy fences along the rear and side property lines of homes in the community to create visual cohesion and enhance privacy. The board voted yes 3-0. I attended that meeting. I asked how the fence lines would be determined. Sandra said the HOA's landscape contractor would reference existing markers. I asked which markers. She said, the ones that are there. I asked for the survey documentation. She said, we'll make it available in the portal. It was never made available in the portal. I sent 2 emails asking. Both were acknowledged with an auto-reply saying the board would respond within 14 business days. Neither response ever came. I flagged it to my neighbor Frank, who'd been in Elm Grove for 20 years. He said, Mara, Sandra has been doing things her way for a long time. She's careful. She makes sure she has enough cover to keep people from fighting back. He paused. But she's also gotten sloppy. She thinks nobody's watching anymore. I filed a formal written request for the survey documentation through the HOA's official process. Certified mail, return receipt, everything. I received back a letter signed by Sandra stating that the HOA relied on established boundary references and that the fence project had been approved by the board. No survey attached. In September 2022, Sandra's landscape contractor, a company called Greenline Solutions, owned by Sandra's brother-in-law, Rick, began installing fences along the back of properties on our street. I watched from my kitchen window as they worked their way toward my lot. On October 3rd, I came home from work to find orange stakes driven into my yard, approximately 2 feet inside my actual property line. I pulled one up and looked at it. It had a Greenline Solutions sticker on the side. I put it back and went inside. I needed to think. I called the county surveyor's office the next morning. They confirmed my property line based on the recorded plat. My eastern boundary, the one facing Sandra's property, ran along a specific set of GPS coordinates. The orange stakes were, as I'd suspected, roughly 24 inches inside my land. I documented everything. I photographed the stakes. I photographed my plat map. I printed the county's coordinate data. I created a folder on my desktop labeled Fence. Then I called a property attorney named David Hargrove, whose name I'd gotten from a colleague at work who dealt with an easement dispute. David said my position was straightforward. If the fence was installed on my property without my consent, it was encroachment. I had the right to demand removal, and if the HOA refused, I could sue. He also said the HOA's failure to provide survey documentation before construction could be additional grounds for liability. On October 11th, a Saturday, Greenline Solutions arrived at 7 a.m. with a post-hole digger and a truck full of cedar panels. I went outside in my bathrobe and told the crew supervisor directly, "These posts will be going inside my property line. I need you to stop until this is resolved." The supervisor looked uncomfortable and called someone on his phone. Sandra appeared over her fence, the existing low chain link one, within 4 minutes. She was already dressed, already holding her coffee, already smiling. "Mara," she said pleasantly, "this is a community project. It's board approved. The contractor knows what he's doing." I said, "The posts are going 2 feet inside my property line, Sandra. I verified this with the county surveyor's office." She tilted her head. "The HOA uses its own references." I said, "Your references are wrong." She said, "I'm sorry you feel that way," and turned to the crew. "Go ahead, guys." The crew hesitated. I said, loudly and clearly, "If you install anything on my property without my consent, you are trespassing on private property, and the homeowner, me, will pursue legal remedies against the contractor." The supervisor put down the post-hole digger. He called Rick. Rick showed up 20 minutes later in a white pickup truck. He walked the line with a tape measure, rechecked the orange stakes, and then had a hushed conversation with Sandra by her back gate. I stood in my yard and watched. When Rick walked back to his truck, he said to me, "We'll need to reschedule." Sandra turned to me with a look I hadn't seen before. Not the pleasant smile, not the clipboard condescension. Something colder. "You're going to be very sorry you did this," she said quietly before going inside. I went inside too, took a shower, and called David Hargrove. David said to document the threat. I did. I sent myself a time-stamped email describing exactly what Sandra said, word for word, within 15 minutes of it happening. Then I ordered a professional land survey from a licensed firm, Millstone Survey Associates. Appointment set for 2 weeks out. In the meantime, Sandra began her counteroffensive. Within 48 hours of the contractor standoff, I received 3 new HOA violation notices in my mailbox. My daughter's bicycle, stored on the side of the house, was a prohibited obstruction. My outdoor trash can lid was improperly sealed. My porch light was non-compliant wattage. I photographed each violation notice, photographed the supposed infraction, and sent a formal written response requesting clarification and documentation for each one. I CC'd David Hargrove on every email. Sandra's responses stopped being pleasant. They became clipped, formal, bureaucratic. I also noticed that my Community Link portal, where residents could view their HOA account status, now showed 3 new active violations and a note that my account was under enhanced monitoring. I'd never seen that designation before. I took a screenshot. Frank knocked on my door that week with a 6-pack of beer and a knowing look. "She's doing the same thing she did to the Garcias in 2019, he said. "Enhanced monitoring, then fines. Then she threatens to put a lien on your house if you don't pay." The Garcias sold. I popped open a beer. I asked Frank if he knew what had happened with the Garcias specifically. He said Sandra had claimed their fence was non-compliant and had gotten the board to fine them $300 a week until they either fixed it or sold. They sold. Sandra had been close with the buyers. I looked up the Garcia property sale in the county recorder's office. It had sold in October 2019 for $14,000 below Zillow's estimated value at the time. The buyers were a couple named Holloway, as in Deborah Holloway, Sandra's board appointee. I sat with that for a long time. I started going back through my own violation history differently, not as annoyances to be dismissed, but as a pattern. 19 violations in 6 years. All minor. All technically defensible by Sandra. All creating a paper trail of non-compliance that would make my property look problematic to any buyer or lender. I pulled my original mortgage documents and read the HOA disclosure section. The lender had required confirmation that there were no active violations at closing. If Sandra had been maintaining a shadow record of enhanced monitoring on my property through CommunityLink, it could theoretically affect a refinance or future sale. I sent a formal legal records request, certified mail, return receipt to the HOA for the full CommunityLink records for my property, going back to my move-in date. I cited Ohio Revised Code Section 5312.10, which requires HOAs to make records available to homeowners upon written request. I gave them 14 days. Sandra's response arrived on day 13. It was a letter, not from her, but from an attorney named Gregory Fain of Fain and Sutter LLC, stating that the HOA's digital records were proprietary operational data, not subject to homeowner disclosure requirements, and that any further requests should be directed to counsel. I forwarded the letter to David Hargrove. He said, "She hired a lawyer." I said, "She hired a lawyer." He said, "Good. That means she's scared." I felt the first warm ember of something that might have been hope. The Millstone survey came back on October 28th. It was thorough, GPS verified, and unambiguous. My eastern property line ran exactly where I said it did, and the orange stakes green line had planted were 23 inches inside my boundary. The surveyor's report was 41 pages and included aerial overlays. I made 5 copies of the survey. I sent one to David. I kept one in a fireproof safe. I sent one to the county recorder's office. And I mailed one certified return receipt to Sandra Kowalski at 15 Birchwood Court. I included a cover letter that said simply, "Please see the enclosed professional survey. The fence, as proposed, would encroach on my property. I expect the project to be revised accordingly." 4 days later, a Thursday, November 1st, I came home from work and found the fence already installed, 6 feet tall, cedar, HOA plaque bolted to the post. My entire garden was on Sandra's side of the wood. I stood in my yard and looked at it for a long time. Walter the beagle sat beside me, confused about where his running path had gone. Lily came out and said, "Mom, where's my strawberries?" I told her they were just on the other side. She asked if we could get them back. I said yes. I called David Hargrove from my driveway. He picked up on the second ring. I said, "She built the fence." He was quiet for a moment. Then he said, "Okay, now we have an encroachment. Now we have a case." He told me to photograph everything, document the date and time, and not to touch or move anything. I did exactly that. That night, I sat at my kitchen table after Lily went to bed and opened my laptop. I had the survey. I had the violation notices. I had the screenshots from CommunityLink. I had Sandra's threat timestamped. I had the Garcia property sale records. I had the attorney letter. I had 41 pages from Millstone survey. I had a case. David filed an emergency motion for injunctive relief on November 4th, asking the court to order the HOA to stop any further construction and to preserve the current state of the fence pending resolution of the encroachment claim. The motion was granted the following Monday. Sandra received a copy. I know she received it because Deborah Holloway called me that Tuesday morning. Not Sandra, Deborah. She said, "Mara, I think there's been a misunderstanding. Sandra is open to a conversation." I said, "My attorney is open to a conversation. Tell Sandra to have Gregory Fain call David Hargrove." Deborah hung up. The conversation between the attorneys lasted 3 weeks and produced nothing except a letter from Fain claiming the survey was methodologically flawed and that the HOA stood by its installation. David sent back a 4-page rebuttal citing the GPS coordinates, the county plat, and the millstone certification. Fain went quiet. Meanwhile, Sandra escalated the violation campaign. In November alone, I received 8 new notices. My gutters had non-compliant debris. My garage door had a microcrack in the panel surface. My front doormat was non-HOA approved design. I photographed and documented every single one and continued paying the fines while they were under dispute. I also began talking to my neighbors. Not loudly, not campaigning, just having conversations. I learned from Maria 3 doors down that she'd been under enhanced monitoring for 2 years after she objected to a fee increase at a board meeting. I learned from the Nguyen's at the end of the court that they'd been fined for their children's basketball hoops 6 times. I started a group text. I called it Birchwood Neighbors. By the end of the first week, 11 of the 47 households had joined. By the end of the second week, it was 23. I didn't push. I just shared my story and asked if anyone had experienced similar things. The responses came in steadily, like a slow flood. Someone in the group, I later found out it was a man named James Okafor at number 22, had actually attended every HOA board meeting for the last 3 years and had kept his own notes. He shared them with the group. The patterns were staggering. Sandra had voted on her own house's compliance 6 times. She'd voted to approve contracts with Greenline, her brother-in-law's company, 11 times without disclosing the relationship. Ohio HOA law requires board members to disclose conflicts of interest before voting on related matters. Sandra had never disclosed her relationship with Rick or Greenline to the broader membership. James's notes showed the votes, the contracts, the amounts. Greenline had received over $140,000 in HOA funds over 5 years. I sent this information to David Hargrove. He said it broadened the scope of what we were dealing with, from property encroachment into potential breach of fiduciary duty and self-dealing. He recommended I also file a complaint with the Ohio Attorney General's office, which handles HOA fraud complaints under consumer protection statutes. I filed that complaint on November 19th. Took me 2 hours to complete the form and attach the supporting documentation. I sent copies to David and kept the submission confirmation number in my folder. The AG's office acknowledged receipt within 5 business days. Sandra's response to whatever she was hearing through her attorney was to call a special board meeting for December 3rd, a Tuesday evening at 7 p.m. in the community clubhouse. The agenda, posted on Community Link, listed one item: amendment to CC and RS regarding property boundary compliance and HOA authority. David reviewed the proposed amendment when I forwarded it to him. He read it twice and then called me. Mara, he said. She's trying to amend the CC and RS to retroactively authorize the fence placement. If this passes, she has a legal cover argument. I asked what we needed to do. He said, make sure it doesn't pass. Under Ohio law, CC&R amendments require approval by at least 67% of the membership, not just the board. That meant Sandra needed 32 out of 47 homeowners to vote yes. I went back to the Birchwood Neighbors group text and explained what was at stake. 23 households showed up to that December 3rd meeting. Sandra stood at the front of the community room in a blazer, looking composed. Deborah sat to her left. Phil, appearing in person for the first time I could remember, sat to her right looking slightly terrified. Sandra presented the amendment as a clarification to help avoid future confusion about community improvement projects. She spoke for 15 minutes without once using the words fence, encroachment, or lawsuit. She was smooth. I'll give her that. When she opened the floor, I raised my hand. She called on me with a smile. I stood up and said, "This amendment, if passed, would retroactively authorize the placement of a fence that professional surveyors have documented is 23 inches inside my private property. It would essentially vote to legalize a trespass." The room got very quiet. James Okafor raised his hand next. He read, from printed notes, the dates and amounts of every Greenline Solutions contract the board had approved over 5 years, and asked Sandra to confirm whether Greenline's owner was her brother-in-law. Sandra said, "That's not relevant to tonight's agenda." James said, "I think it is." The room buzzed. Maria from number 11 stood up and said she'd been under enhanced monitoring for 2 years without knowing what it meant and asked Sandra to explain what the designation did to a property's standing with lenders. Sandra said, "That's a portal technical matter." Maria said, "It's my house. It's not technical." The vote on the amendment was called. The board voted yes, Sandra, Deborah, Phil. The floor voted no, 22 of the 23 homeowners present. The amendment failed spectacularly 22-3. Sandra's smile did not waver, but her jaw tightened. I saw it from the third row. After the meeting, I was standing in the parking lot when Deborah Holloway approached me alone. She looked genuinely shaken. She said quietly, "I need you to know I didn't know about the survey. Sandra told us the contractor had verified the lines." I looked at her. "Deborah, you voted to install it." She looked at the ground. "I know." That was the first crack. Deborah wasn't the villain. She was something worse in some ways, a follower who hadn't asked enough questions. But she was also, potentially, someone who might start asking them now. December moved fast. David filed the formal encroachment lawsuit on December 10th. Mara Chun versus Elmgrove HOA seeking removal of the fence, restoration of my property, and damages. The filing was public record. It appeared in the local legal notices section of the county newspaper. 2 days after the filing appeared in print, I got a call from a woman named Andrea Sloan. She said she was a reporter for the Millbrook Gazette, the local weekly. She'd seen the legal notice and was curious about the story. I said I'd call her back. I talked to David first. David said talking to a reporter was my decision, but to be factual, not emotional, and not to say anything that could be characterized as defamatory. I called Andrea back. I was factual. I gave her the survey numbers, the filing date, the Greenline conflict of interest information that was in the public record. She was thorough. She asked good questions. The Millbrook Gazette piece ran on December 22nd. The headline was, "Elmgrove Homeowner Sues HOA Over Fence Built on Her Property." It was a quarter-page story. It mentioned the survey, the lawsuit, and Sandra's name and role. It did not mention Greenline. Andrea said she wanted more confirmation before including it. Sandra's response appeared in my mailbox 3 days later, on December 26th, the day after Christmas. It was not a legal document. It was a personal letter, typed and signed but recognizably her voice, accusing me of weaponizing the media, creating division in the community, and pursuing a personal vendetta against the HOA leadership. I photographed the letter and sent it to David. He said, "Keep it. It's relevant to motive." I asked what we were going to do next. He said, "We wait for discovery, and we let her keep making mistakes." He paused. "And she will." He was right. Sandra made her next mistake the second week of January. On January 8th, a Wednesday, I came home to find that the gate in the new fence, which connected Sandra's yard to the strip of my property now enclosed on her side, had been opened, and my irrigation lines, which were still running on my property under the fence footprint, had been cut. Cleanly. With a tool. I photographed the cuts. I called my irrigation company, Clearwater Systems, to document the damage. The technician estimated the cuts had been made within the last 24 to 48 hours. He wrote it up in a service report. I added it to the folder. I also installed 4 outdoor security cameras that week, front, back, both sides. They recorded in 1080p with night vision and stored footage in the cloud. I positioned one of the rear cameras at an angle that captured the fence line directly, including the gate. The cameras caught something on January 14th at 2:11 a.m. A figure, slight, in dark clothing, carrying something, opened the gate from Sandra's side and spent approximately 4 minutes on my property before going back through the gate. The footage was grainy at night but clearly showed the gate being used. I sent the footage to David immediately. He said it was significant but not yet conclusive. He wanted to file a supplemental claim for the irrigation damage and the trespass, which he did on January 16th. He also suggested I get a motion sensor light for that corner of the yard. I bought 2. In February, something shifted. Phil, the third board member, resigned. He sent a brief email to the HOA listserv saying he was stepping down for personal reasons. He didn't say more. But James Okafor, who had his ear to the ground in this community better than anyone, told me Phil had been at a church event where Sandra had apparently said some things about Phil's loyalty that had gotten back to him. Phil's resignation left the board with only Sandra and Deborah. Under the HOA bylaws, a 2-person board couldn't conduct binding business without a quorum of 3. Sandra would need to appoint a replacement, and to do that, she needed the existing board to vote on it. She and Deborah voted to appoint a man named Craig Simmons, who lived at the far end of the street and rarely came outside. I asked James if he knew Craig. He said Craig was nice but completely disengaged. He worked from home, kept to himself, had moved in 18 months ago and never attended a meeting. He'd be easy for Sandra to manage. The replacement went through. The board was back to 3. February was strangely quiet. No new violation notices. No letters from Sandra. No calls from Deborah. The lawsuit was in early discovery. David was gathering documents. Sandra's attorney was responding slowly, requesting extensions. The neighborhood group text hummed along with ordinary things. Someone's package had been stolen. Someone wanted to organize a spring cleanup. I used the quiet to prepare. I went through every piece of documentation I had and organized it into a structured exhibit folder. I color-coded it. Red for violation notices, blue for survey documents, green for financial records, yellow for correspondence, orange for security footage. I printed everything twice and stored one set off-site at my sister's house. I also did something I'd been putting off for months. I got a proper land appraisal. I hired a certified residential appraiser, Margaret Yee, to assess the current market value of my property and to provide an opinion on whether the encroachment, violation history, and enhanced monitoring designation had affected my property's marketability. Her report took 3 weeks. Margaret's report found that the combination of encroachment, the documented violation record in Community Link, and the active lawsuit had measurably reduced my property's effective marketability in the current market by an estimated $22,000 to $31,000. She compared it to 3 similar properties in the area that had sold without HOA disputes. The number was in writing, signed, certified. I also had a conversation during this lull that I didn't expect to matter as much as it did. Frank, my neighbor on the left, knocked one Saturday and asked if I had time for coffee. I did. We sat at my kitchen table and he told me something he said he should have told me sooner. Frank said that in 2020, Sandra had approached him about selling a strip of his property 6 feet wide, along his eastern boundary. She'd said the HOA had plans for green space. He'd declined politely. Within a month, he'd received his first violation notice in 17 years of living in Elm Grove. She doesn't forgive being told no, he said. Frank also said he'd heard from a former HOA treasurer A woman named Helen who'd moved away in 2018, that Sandra had kept a second set of informal notes about residents, not in community link, something separate, personal. A list, Frank said, of people she considered problems. He'd heard his own name was on it. So was mine. I asked Frank if Helen would be willing to talk to my attorney. He said he'd ask. 2 days later, Helen Russo, now living in Columbus, agreed to a phone call with David. She confirmed the existence of what Sandra had called her community health log, a private document she maintained on her personal laptop, separate from official HOA records. David said if we could get access to that document, or even establish its existence in discovery, it could be transformative. It might show a systematic pattern of targeting specific homeowners. He filed a supplemental discovery request specifically seeking any personal notes, logs, or unofficial documents maintained by Sandra Kowalski in connection with her HOA duties. Sandra's attorney objected, of course, but the objection was logged, and the request was on the record. David said, "She'll fight it, but now we know it exists and she knows we know." I sat back in my chair and felt something I hadn't felt in months. Momentum. March arrived cold and wet, and Sandra came back swinging. On March 3rd, a Monday, I received a formal notice from Fain and Sutter LLC stating that the Elm Grove HOA intended to countersue me for interference with community improvement projects, harassment of HOA board members, and defamation via media engagement. The filing landed in David's inbox the same day. David called me that evening. He said the counterclaim was aggressive and largely without merit, but it would cost money and time to fight. He believed it was designed to exhaust me financially, to make the litigation so expensive that settling would seem more attractive than winning. "This is what she does," he said. "She makes it cost more than it's worth." I sat with that for a night. I thought about the $22,000 to $31,000 the appraiser said I'd already lost on paper. I thought about the $3,000 in fines I'd paid over 6 years. I thought about my strawberry beds on the other side of that cedar fence. I thought about Lily asking if we could get them back. I called David in the morning and said, "Fight it." The counterclaim got local media attention. Andrea Sloan at the Gazette ran a follow-up piece that mentioned the countersuit. The headline was neutral, HOA countersues homeowner in fence dispute. But the comment section on the Gazette's Facebook page was not neutral at all. 46 comments in 24 hours. Sandra was not popular online. Someone in the Birchwood Neighbors group text, Maria, shared the Gazette article to a local Facebook group called Millbrook Community Watch, which had nearly 4,000 members. Within 3 days, my story had been shared 212 times. I started getting messages from strangers, other people in HOA disputes, former Elm Grove residents, people who just wanted to say they were rooting for me. I did not post publicly. I did not comment. I directed everyone who reached out to David's firm. But I read every message and I kept them in a folder. When you've been dealing with someone who makes you feel small and powerless, knowing that strangers on the internet are invested in your fight is not nothing. On March 11th, my security cameras caught Sandra at the fence line again, this time in broad daylight. She was measuring something, running a tape measure along the fence from her side, stopping at specific intervals and writing in a small notebook. She spent about 20 minutes doing this. I saved the footage. I had no idea what she was measuring or why. I sent the footage to David. He said to note it but not to draw conclusions yet. 2 weeks later, I found out what she'd been doing. She'd had a landscape architect draw up a plan to convert the encroached strip of my property, with the fence now in place, into a formal patio extension for her yard. She intended to pour concrete. The landscape plans came to light because Greenline Solutions submitted a permit application to the county for patio installation at 15 Birchwood Court. The application described the work area using GPS coordinates that included land that was mine. County permits are public record. James Okafor, who had set up a Google alert for Greenline Solutions after learning about the conflict of interest, caught it. James sent the permit application to the group text at 6 a.m. on a Friday. My phone lit up for 20 minutes straight. I forwarded it immediately to David. He filed an emergency objection with the county building department within 2 hours, citing the active encroachment lawsuit and the survey evidence. The permit was put on hold pending review. Sandra found out about the hold the next day. I know because I could hear her on her back porch on the phone, voice raised, for about 15 minutes. I couldn't make out words through the fence. But Walter the beagle sat by the fence and his ears were flat. He has good instincts. The permit incident changed something in Sandra's behavior. The pleasant composure, the smile, the carefully chosen words began to fray. She began filing HOA violation complaints on every house whose resident had joined the Birchwood Neighbors group. Within a week, 11 of my neighbors had received new notices. People were angry and frightened. An emergency call in the Birchwood Neighbors group text at 9 p.m. that night had 31 of the 47 households participating, the highest we'd ever had. People were scared about fines, about their records, about their property values. I said, "She's doing this because we have power together, and she wants to make us afraid to use it. Don't respond to the notices yet. Let's talk to David." David agreed to do a group call. He walked 23 households through their rights under Ohio HOA law, including the right to call a special meeting with a petition signed by 20% of the membership, which was 10 households. We had 31. He explained what a petition for removal of a board member required. The room, metaphorically, got very still. Under Ohio Revised Code 5312.05, the membership of an HOA can remove a board member by a majority vote at a properly noticed meeting. The process required a petition, a 30-day notice, and a membership vote. 20% to call the meeting, majority to remove. We had the numbers to call it. We might have the numbers to win it. I drafted the petition with David's guidance. It was factual, unemotional, and specific. It cited the undisclosed Greenline conflict of interest, the fence encroachment, the AG complaint, the manipulation of community link records, and the pattern of retaliatory violation notices. 31 homeowners signed it within 4 days. We needed 10. I delivered the petition to Sandra by certified mail on April 4th. Return receipt. I also hand-delivered a copy to Deborah and Craig, the other 2 board members, and to Gregory Fain's law office. The notice for the special meeting was set for May 5th, a Monday, 7 p.m., at the community clubhouse. Every household in Elm Grove was notified. Sandra's response was to schedule a competing event. She sent out a flyer, actual paper, put in every mailbox personally, announcing an annual spring community gathering for the same date, same time at the clubhouse. A cookout, lawn games, a bouncy castle. She was going to try to make our meeting feel like a party crasher. I called the clubhouse management office. The facility was owned by the HOA but managed by an independent company called ComSpace LLC. I explained the situation and asked whether a properly noticed membership meeting had priority use rights over an informal gathering. The ComSpace manager looked into it and called back. Yes, the special meeting had priority. The spring gathering could happen in the parking lot. Sandra's flyer was out there, though, and some residents, particularly newer ones, the ones who hadn't been in the group text, the ones who'd gotten their information only from Sandra's version of events, genuinely didn't know what was happening. I began knocking on doors. I spent 3 evenings in late April, after work, after dinner, after Lily was in bed, with Frank watching her at my house, going door to the households that hadn't joined the group text. I didn't argue. I didn't campaign. I showed people the survey. I showed them the Green Line contract records. I showed them the appraisal. And I listened. A few households said they were staying out of it. That's fair. 2 households told me they supported Sandra and asked me to leave. I thanked them and left. 7 households asked if they could join the group text. By the time I was done knocking, the count was 38 households who knew the real story. On April 22nd, something happened that I hadn't anticipated. Craig Simmons, Sandra's hand-picked 3rd board member, the quiet one who worked from home, called David Hargrove's office directly. He said he wanted to speak with David confidentially about the board's operations. David told me that evening. I said, "That's interesting." I don't know exactly what Craig said to David in that call, because attorney-client privilege flows differently between parties. But David told me, carefully, that Craig had asked questions that suggested he was reconsidering his position on certain matters, and that I should not be surprised if things shifted in the days before the meeting. I sat with that. A week before the meeting, the Ohio Attorney General's office sent a letter to the Elm Grove HOA's registered address and to Gregory Fain's office. It was a formal inquiry, not a finding, not a charge, but an official letter asking the HOA to preserve all financial records, board minutes, and contractor agreements for review. AG letterhead. Certified mail. David texted me a photo of the letter at 8 a.m. that Tuesday. I read it twice. Then I made coffee, poured it slowly, and stood at my kitchen window looking at Sandra's fence. For the first time since October, I let myself believe that this was going to end well. Sandra responded to the AG letter by appearing at my door for the first time since the fence went up. She knocked on a Wednesday afternoon. I happened to be working from home. I opened the door. She looked different, less composed, something around the eyes that was unfamiliar. She said, "I'd like to talk, Mara." I said, "You can have your attorney call David Hargrove." She said, "I'm not here in an official capacity." I said, "Sandra, everything between us is official at this point." She stood there for a moment. Then she said, "I was trying to make this community better. I hope you understand that someday." I said, "I understand you built a fence on my land," and closed the door. I texted David immediately. He said I'd handled it correctly. He also said it was the behavior of someone who felt the walls closing in. "She's looking for a way out," he said. "Don't give her one on her terms." I said I wouldn't. The 10 days before the meeting were the most tense. I kept going to work, coming home, helping Lily with math homework, feeding Walter, watering the small container garden I'd started on my front porch since my beds were behind Sandra's fence. I did not let myself feel it until the meeting. I didn't have room for it. I learned 2 days before the meeting that Deborah Holloway had retained her own attorney, separate from Fain and Sutter, who represented Sandra and the HOA. The attorney was a woman named Patricia Chung. I didn't know what this meant, but David said it almost certainly meant Deborah was preparing to distance herself from Sandra's decisions. The board was fracturing. The night before the meeting, Lily asked me what was happening with the fence. I'd been vague with her. She's 9, and I didn't want her carrying the weight of this. I told her I was working on getting our garden back. She said, "Is the lady next door mean?" I thought about it and said, "She's made some choices that have hurt us, and we're fixing it." Lily nodded. "Like when I broke the thing and had to apologize and fix it?" "Exactly like that," I said. I barely slept. I went over my notes, my documents, David's advice about how to conduct myself during the meeting. Be calm. Be factual. Let the documentation speak. Don't engage emotionally. Don't let her bait you into looking like the aggressor. You don't need to perform anger. The facts are angry enough on their own. May 5th arrived gray and cold for a Monday evening. I drove to the clubhouse early and helped David and James set up a projector and screen. We had a slide presentation, survey overlays, contract records, community link screenshots, the appraisal summary. 37 of 47 households were present in person. 2 sent written proxies with James. That was 39 households represented. Sandra arrived 8 minutes late, the first time I'd ever seen her late to anything. She was with Gregory Fane, who looked like he'd rather be anywhere else. Deborah arrived separately, sat at the far end of the board table, and did not make eye contact with Sandra. Craig Simmons sat in the middle, very still, hands flat on the table. I called the meeting to order because as the petition organizer, the bylaws gave me that right. I welcomed everyone. I explained the purpose and the process. I said this was not a trial and not a witch hunt. It was a membership exercising a legal right under Ohio law. I said we would hear from all sides and then vote. Sandra's jaw was set. She did not look like she was listening. The presentation took 40 minutes. David handled the legal framing. James walked through the financial records. I presented the survey and the appraisal. Maria presented her own story about enhanced monitoring. The Nens showed their basketball hoop fine notices. We did not editorialize. We narrated. The facts were enough. Sandra was given equal time to respond. She stood and spoke for about 25 minutes. She talked about community standards, about her years of service, about everything she'd built for Elm Grove. She did not address the survey. She did not address Greenline. She said the enhanced monitoring was a quality assurance tool and that any resident could access their records at any time through the portal. Maria held up the letter from Fane and Sutter saying the records were proprietary. The room murmured. Then Craig Simmons did something no one expected. He asked to speak. Sandra looked at him. He cleared his throat and said, "I want to make a statement as a board member." He unfolded a piece of paper. He said that since joining the board 3 months ago, he had been unable to access certain financial records, that he had not been informed of the AG inquiry until after it happened, and that he believed the board had not operated with the transparency its members deserved. He said he was voting to remove Sandra. The room erupted. Not shouting, surprised, urgent, disbelieving conversation all at once. Sandra stared at Craig. He looked at the table. Deborah put her face in her hands. Gregory Fane whispered something in Sandra's ear. Sandra said, loudly, "Craig, you don't understand what you're doing." He said, "I think I finally do." The vote was called. 34 households voted to remove Sandra Kowalski as HOA president. 3 voted against. 2 abstained. Under the bylaws, a majority was sufficient. Sandra was removed. She did not leave immediately. She sat in her chair for a long moment after the vote was announced, looking at the table. Then she stood, picked up her folder, and walked out. Gregory Fane followed. Deborah stayed. The room was very quiet and then very loud all at once, and Frank, who was sitting in the second row, put his hand on my shoulder and squeezed it once. I held it together in the room. I got in my car and cried for about 10 minutes in the parking lot. Then I drove home, paid the babysitter who'd stayed with Lily, and went to bed. Walter slept at the foot of my bed. The fence was still there, but for the first time it felt temporary. The next morning, David called with an update. Deborah Holloway had reached out to Patricia Chung overnight and was prepared to cooperate with the AG's investigation. She confirmed the existence of Sandra's personal community health log and said she had seen it on at least 2 occasions. She didn't have a copy, but she could describe its contents. This was significant. The AG's office moved faster after that. Within 2 weeks of the May 5th meeting, investigators formally requested Sandra's personal laptop and any external storage devices as part of the inquiry into the Greenline contracts. Sandra's attorney objected. The AG obtained a subpoena. The laptop was produced. I wasn't in the room when whatever was on that laptop was reviewed, and I never saw its contents directly. But David, through the legal process, received summaries of what was found. The community health log was real. It contained entries for 31 Elm Grove homeowners. It tracked what Sandra described as their threat level and compliance posture. Mine had been updated 47 times since 2019. The log also contained entries that weren't about compliance at all. There were notes about neighbors' finances, overheard conversations, things gleaned from county records, credit issues she'd become aware of, notes about who was vulnerable, notes about property values and sale timings. It was, as David put it to me with characteristic restraint, extensive and concerning. And then there was the entry about the fence. Written in Sandra's own words, dated 3 days before Greenline installed the posts. Survey confirms encroachment by 23 inches. Proceeding anyway. Emchen unlikely to fight long-term. Financial pressure should resolve. She'd known. She'd known the fence was on my land before she built it, and she'd built it anyway because she'd bet I wouldn't have the endurance to fight. When David read me that entry over the phone, I had to sit down. I was in my office at work, door closed. I sat down and I read it again. She'd known. Every smile, every, "I'm sorry you feel that way," every violation notice. It was a system. It was deliberate. She'd looked at me and calculated that I would break. She was wrong. I cried again, briefly at my desk. And then I collected myself and went back to work, because I had a staff meeting in 20 minutes and the county's storm drain project wasn't going to manage itself. But I held that information close for the rest of the day, and when I came home and Lily ran to the door to show me a drawing she'd made of our garden, I held her for a little longer than usual. The civil lawsuit moved faster once the AG's investigation accelerated. Fain and Sutter withdrew from representing the HOA. They could no longer represent both the HOA and Sandra personally, as the interests were now diverging. The HOA's new interim board, Deborah, Craig, and a newly elected member named Thomas Webb from number 31, retained new counsel. The new HOA council made contact with David within a week. They were cooperative. They acknowledged the encroachment. They acknowledged the Greenline conflict of interest. They asked what resolution would look like from my side. David and I talked for a long time about what I wanted. Money, yes, for the appraisal loss, the fines I'd paid, the survey, the attorney fees, the damaged irrigation. But more than that, I wanted the fence removed. I wanted my property back. I wanted the community link records corrected. I wanted a formal apology from the HOA in writing. And I wanted Greenline Solutions to be permanently excluded from HOA contracts. Sandra, however, was not done. Even removed from the board, stripped of her platform, and under AG investigation, she had not run out of moves. What she did next was something I hadn't anticipated, and it was the most dangerous thing she'd attempted yet. On May 17th, 12 days after the membership vote, Sandra filed an injunction attempt in civil court seeking to have the removal vote nullified on procedural grounds. Her personal attorney, a new one, not Fain, argued that the meeting notice had been defective because it hadn't been posted to Community Link with sufficient lead time. The argument was thin, but it had to be answered. David answered it. He submitted the certified mail receipts, the Community Link posting timestamp, and the email confirmation sent to all 47 households. The injunction was denied within a week. Sandra appealed. The appeal was also denied. She spent somewhere in the range of $8,000 in attorney fees on a motion that lasted 12 days total. While the injunction was still pending, Sandra began a whisper campaign. She went door to door herself, the same thing I'd done in April, but with a different message. She told people the removal had been orchestrated by outside parties. She told 2 of my neighbors that David Hargrove was known for manufacturing HOA conflicts. She told 1 household that I had a history of property disputes in my previous city. None of it was true. The neighbor who told me about the previous city claim was genuinely apologetic. I knew it was probably wrong, she said, but I felt like I should tell you. I thanked her. I called David. He said, "That's potentially defamatory. Document it." I went back to the neighbor, explained what defamation meant, and asked if she'd be willing to put in writing what Sandra had said to her. She said yes. 2 other neighbors came forward with similar accounts over the next week. All 3 wrote statements. David added them to the file. The picture was building of someone who was not backing down, who was escalating, who was moving from institutional power plays to personal attacks because she'd lost the institution. On May 24th, Sandra called animal control on Walter. She reported him as an aggressive dog who had threatened her while she was walking on a public sidewalk. Animal control came to my door, very apologetic, to document the complaint. I showed them Walter. He was asleep on the couch under a fleece blanket. The animal control officer said, "Yeah, I'm going to note this was an unsubstantiated complaint." He did in writing. I asked for a copy. The following week, Sandra called the county health department to report what she described as a possible vermin infestation at my property. A health inspector came. She found nothing. She gave me a copy of her report noting the complaint and findings. "You're the second call this week from your street," she said, unprompted. Different addresses, same complainant. I asked her to document that. She did. Sandra was calling county agencies on my neighbors too. Maria had a code enforcement visit about her fence. The Nguyen's had an anonymous tip about their driveway. Frank, who'd been in Elm Grove for 20 years without a single code issue, received a visit about a cracked sidewalk square. Every call traced back to the same pattern, the same day, the same phone number when investigators looked. David filed a harassment complaint on my behalf with the local police department. Not criminal, civil. A documented record that Sandra Kowalski was engaging in a pattern of vexatious agency complaints targeting specific households. The officer who took the report said, "We've been getting a lot of calls from this address lately." He noted the complaint. Birchwood Neighbors was now 41 households. We organized. When an agency showed up at anyone's door, someone from the group would go stand with that neighbor as a witness. We documented every visit, every complaint, every inspector's finding. We built a binder. James kept a master log. Sandra's behavior was becoming erratic enough that Gregory Fain, her former attorney, sent her a letter, which I later learned about through discovery, advising her in writing to cease contacting neighbors and county agencies and to allow her legal representation to manage the situation. She apparently did not respond to this letter. On June 3rd, I came home to find a real estate agent's lockbox on my front door. Not Sandra's, mine. A magnetic lockbox, the kind used for property showings. I had not listed my house for sale. I had not authorized any agent to access my property. I called the number on the box. The agent, Marion Colt from Prestige Realty, said the listing had been submitted by the property owner. I said I was the property owner and I hadn't submitted anything. There was a long pause. The listing had been submitted online through Prestige Realty's portal, using my name, my address, and a property description that had clearly been written by someone who knew the house, describing the layout, the lot size, the county water access. It had been listed for $67,000 below market value, with a note, "Motivated seller, must close in 30 days. Listings go into the MLS immediately." It had already been active for 6 hours. Marion Colt was horrified. She pulled the listing immediately. She said she'd have to report the fraudulent submission to her broker and, potentially, to law enforcement. I said, "Please do." I called David at 6:30 p.m. He said, "Mara, this is fraud. This is identity fraud and real estate fraud. This is criminal." He said we needed to file a police report that night. I filed the police report at 8 p.m. The detective who took it, a woman named Lorena Vasquez, was focused and efficient. I gave her the MLS listing printout, Marion Colt's contact information, and everything I had on Sandra. Detective Vasquez said she recognized the address. She'd received the harassment complaint David had filed earlier. She said, "I think we have a pattern here." The fraudulent listing was the moment things went from civil dispute to criminal investigation. Detective Vasquez opened a case the next morning. Prestige Realty's IT team provided the IP address and device fingerprint used to submit the fraudulent listing. The submission had come from a device on Sandra's home Wi-Fi network, traceable via her ISP. Sandra was served with a criminal complaint on June 9th, identity fraud, real estate fraud, and wire fraud, all Class F felonies under Ohio law. I watched from my front window as the unmarked sedan pulled up. I hadn't told anyone it was coming, not even Frank. I just happened to be standing there watering my container tomatoes. Sandra's new attorney, not Fain, not anyone local, someone from a Columbus firm, managed to get the initial court appearance set for 3 weeks out. Sandra posted bail that evening, walked back into her house, and did not come outside again for 5 days. The arrest made the Millbrook Gazette's front page. Not a quarter column, the front page, above the fold, with a photo pulled from the HOA's public website. Andrea Sloan had done her homework. The piece was fair, factual, and devastating. Former HOA president charged with fraud in neighbor dispute was the headline. The comment section had 214 responses within 12 hours. National community legal watchdog groups picked up the story. A legal blogger called HOA Advocates published a summary that was shared thousands of times. I received interview requests from 3 different media outlets. David advised me to decline all of them while criminal proceedings were active. I declined them all. In the middle of all this, the criminal case, the civil suit, the media attention, I got an unexpected call. It was from a woman named Teresa Park, who said she'd been a resident of Elm Grove 7 years ago, before Sandra's tenure really consolidated. She said she'd left because of Sandra, and she'd been following the story online. Teresa said that when she lived in Elm Grove, Sandra had done something similar to her. Not a fraudulent listing, but a campaign of targeted violations and a threat about her property's market viability, unless she sold. Teresa had sold. She'd sold to a buyer who, she later found out, was a referral from Sandra. She'd never connected it to anything deliberate until now. She was willing to talk to David. David added Teresa to his witness list. He also began looking more carefully at property transactions in Elm Grove over Sandra's 7-year tenure. He found 5 sales that fit a pattern: homeowners under sustained violation pressure, properties sold below market value, buyers with connections to Sandra or her circle. The Garcias, Teresa, 3 others. This information went to the AG's investigation, which was now expanding significantly. What had started as a complaint about HOA financial mismanagement was now looking like something broader, a systematic scheme to depress property values and direct sales. The AG's office sent a second letter to Sandra's attorney indicating the scope of the investigation had widened. I kept going to work. I kept making dinner. I kept helping Lily with homework and taking Walter for walks. People in the neighborhood waved at me more now. Someone left a loaf of homemade bread on my porch. Frank brought over a tomato seedling. "For when you get your beds back," he said. Sandra's attorney filed a motion in the civil case arguing that the criminal proceedings should pause the civil lawsuit. David opposed it. The court agreed with David. The civil case would continue on its own schedule. This was important because it meant the fence issue and the property damages weren't waiting on the criminal timeline. The HOA's new board, Deborah, Craig, and Thomas, formally acknowledged in a board resolution passed at their June meeting that the Green Line fence installation had constituted an encroachment on my property and that the HOA accepted responsibility. They voted to fund the fence removal and property restoration. They sent me a copy of the resolution by certified mail. The resolution was not enough to settle the civil case. The damages still needed to be determined, but it was a significant step. It was the first time in 8 months that the HOA had officially admitted wrongdoing in writing. David said it would make the damages conversation much simpler. On June 15th, something small happened that I have thought about many times since. I was weeding my container garden on the front porch, the one I'd started because my real garden was behind Sandra's fence, and I looked up and Sandra was standing on the sidewalk. Not moving toward me, just standing there. She didn't say anything. I didn't either. She looked at the container garden. Then she looked at me. Then she walked back to her house. I don't know what she was thinking. I don't know if she felt anything, or if whatever she felt was real. But I noticed she looked tired in a way she never had before, and something in me, not pity, but something adjacent to it, flickered for a second before I went back to my weeding. The civil settlement negotiation began in earnest in late June. David and the HOA's new attorney, a woman named Carmen Ortega, worked through the numbers methodically. The encroachment removal and restoration, the appraisal loss, 6 years of fines, survey and attorney fees, the irrigation damage, the fraudulent listing cleanup costs. They arrived at a number. It was significant. I will not disclose the exact figure because the settlement included a non-disclosure clause for the financial terms. What I will say is that it covered everything David had listed and more, included the complete removal of the fence at the HOA's expense, and required the permanent correction of my community link records and the deletion of the community health log data pertaining to me. It also included a formal written apology from the Elm Grove HOA board, signed by Deborah, Craig, and Thomas. It acknowledged the encroachment, the retaliatory enforcement, the community link manipulation, and the harm caused to me and my property. It was 3 paragraphs. I read it once. I put it in the folder. I didn't need to read it again. Sandra was not a party to the civil settlement. The HOA settled on behalf of the organization, and her personal liability remained a separate matter in both the civil and criminal cases. Her attorney was fighting the criminal charges. Her personal civil exposure for the defamatory statements, the fraudulent listing, the harassment, was an ongoing proceeding that David and a separate litigator were handling. Green Line Solutions was the other domino. Rick, Sandra's brother-in-law, had retained his own counsel once the AG inquiry expanded to include the HOA's contracting practices. He had apparently not known about all the layers of what Sandra had been doing. He'd been profiting from the contracts, yes, but the evidence suggested he hadn't been aware of the full scheme. He cooperated with investigators. His cooperation was noted in the eventual outcome. The HOA's new board, meanwhile, was doing something I hadn't expected. They were auditing the last 7 years of board decisions. Every vote, every contract, every expenditure. With Deborah's cooperation and the materials recovered from Sandra's laptop, they were building a full accounting of what had happened. It was going to be ugly. They knew it. They were doing it anyway. Thomas Webb, the new board member from number 31, sent me a personal note, a handwritten card, left in my mailbox. It said, "On behalf of everyone who should have paid closer attention, I'm sorry. You shouldn't have had to fight this hard for what was already yours." I kept that card out of the folder. It went on my refrigerator. Lily noticed the card when she was getting milk one afternoon. She read it and asked who Thomas was. I said he was a neighbor who was helping fix a problem. She said, "That's good. Fixing problems is important." I agreed with her. July 4th came. Our street had a block party, the real kind, organized by the neighborhood, not the HOA folding tables, potluck dishes, sparklers for the kids after dark. Frank made his famous macaroni salad. Maria brought tamales. The Nguyen's brought a cooler of drinks. Sandra's house was dark and quiet. I brought strawberry shortcake, store-bought strawberries, since mine were still behind the fence. But I made the biscuits from scratch. Lily ate 3. Walter stole one off the low table and felt no remorse. It was the best block party I'd ever attended in Elm Grove, and it felt like something that had been held underwater finally being allowed to surface. The fence removal was scheduled for July 22nd. Greenline Solutions was not doing it, obviously. The HOA contracted with a different company, Apex Property Services, to take the fence down and restore the soil, grade the land, replace the irrigation lines, and reseed where the fence footings had disturbed the ground. The estimate was 4 days of work. I took those 4 days off work. I wanted to be there. I stood in my backyard on the morning of July 22nd and watched the first cedar panel come down. It made a sound, a dry crack, then a thump as it hit the ground. Lily, who'd asked to stay home from day camp, cheered. Walter barked twice and then lost interest. By the end of day 1, the fence was gone. The posts were pulled. The hardware was loaded into a truck. My yard was dirt and ruts and empty space where my beds had been, and I had never seen anything more beautiful than that strip of disturbed ground that was mine again, unconditionally, with no plaque and no cedar and no Sandra. The restoration took the full 4 days. New irrigation lines, rebuilt raised beds. The contractor used cedar, which I found satisfying. Reseeded grass between them. I replanted the strawberry runners myself, because I'd been keeping them alive in pots all winter and spring. I dug each one in by hand. Lily helped. On the last day of the restoration, Frank brought over a bottle of champagne at about 4 p.m. and stood on the edge of my yard admiring the rebuilt beds. He said, "You know what my favorite part of this is?" I said, "What?" He said, "She measured this strip 3 times. She made plans. She was going to pour concrete." He shook his head. "And now you've got strawberries. She built her fence on my land, so I made her backyard completely useless. I opened the champagne right there in the yard, dirt still on my hands. We toasted with paper cups, me, Frank, Lily with sparkling juice, Walter attempting to drink from the bottle before I redirected him. It was not elegant. It was perfect. The afternoon sun hit the rebuilt beds at a low angle and the cedar smelled fresh and clean. But I knew the story wasn't finished. The fence was down. The civil case was settled. My yard was mine. But Sandra Kowalski still lived next door. She was still fighting the criminal charges. Her personal civil case was still pending. And in a week, the AG's office was scheduled to announce the outcome of their 6-month investigation into Elm Grove HOA's financial practices. I received a call from an investigator at the AG's office, a man named Richard Holt, on July 29th. He wanted to walk me through the findings before the public announcement, as the complainant who had initiated the investigation. He was professional, measured, and thorough. He said the findings were significant. He said I should be prepared for attention. The AG's investigation had found that over Sandra's 7-year tenure as HOA president, she had directed approximately $143,000 in HOA contracts to Greenline Solutions without disclosing her familial relationship to the vendor, in violation of Ohio nonprofit conflict of interest statutes. It had also found systematic manipulation of the Community Link platform to target specific homeowners. Most significantly, the investigation had found evidence of what Holt described as a coordinated property devaluation scheme, a pattern of sustained enforcement, pressure on targeted homeowners, timed to coincide with outreach from buyers connected to Sandra, resulting in at least 5 below-market sales over 7 years. The estimated total harm to displaced homeowners exceeded $180,000. Holtz said the AG's office would be filing civil enforcement actions against Sandra personally, seeking disgorgement of financial benefits she'd received from the scheme, which included a referral fee arrangement with at least one of the connected buyers, and civil penalties. The criminal case was a separate proceeding by the county prosecutor. Both were moving forward. I thanked him and hung up. I sat on my back porch and looked at my garden. The strawberry runners were already showing new growth. The soil was soft and dark. My irrigation lines were running on a timer. Everything was where it was supposed to be, and the cost of getting it there had been enormous, and I was glad I hadn't stopped. The night before the AG announcement, Sandra's attorney filed an emergency motion in the criminal case seeking a continuance and a change of venue, arguing that local media coverage had made a fair trial impossible. The motion was denied on both counts within 48 hours. I heard from Detective Vasquez that Sandra's attorney was now in negotiations with the county prosecutor about a possible plea arrangement on the criminal charges. The attorney was said to be arguing that Sandra had acted under significant emotional stress, and that her actions, while wrong, were not those of a habitual criminal. Detective Vasquez relayed this information to me as the victim in the case and asked how I felt about a potential plea. I said that wasn't my call to make, but I wanted her to know I believed the scheme had been deliberate and calculated, not impulsive. I provided a written victim statement. My victim statement was 4 pages. I did not write it in anger. I wrote it in detail. I described the 6 years of systematic harassment, the 27 violation notices I'd eventually received, the targeted timing of enforcement, the fence built knowingly on my property, the fraudulent listing at 2 a.m. filed from her home network, and Sandra's own words from the log, "Emchin unlikely to fight long-term." I wrote, "The harm was not incidental to Sandra Kowalski's actions. It was the intended outcome." She looked at me and calculated that I would not have the resources, the time, or the determination to resist. This calculation should be part of the court's consideration of intent. Detective Vasquez said the victim statement would be part of the case record regardless of whether a plea was entered. I appreciated that. In August, something happened that I hadn't been tracking directly but which pulled everything into focus. The Millbrook Gazette ran a second feature, not about my case specifically, but about the 5 families the AG's investigation had identified as victims of the broader scheme. The Garcias were in it. Teresa Park was in it. 3 other families I'd never met. The Garcias, Eduardo and Lena, had sold in 2019 under sustained fine pressure. They'd moved 30 miles away. The buyer, connected to Sandra's network, had resold the house 2 years later for $47,000 above what they'd paid. A profit generated, in part, by the artificial depression of the Garcia sale price. Eduardo Garcia was quoted in the article saying, "We thought we'd done something wrong. We lived with that for years." I read that sentence 4 times. Teresa Park said she'd felt too embarrassed to fight, and had assumed no one would believe her over a 7-year HOA president. She said reading about my case online was the first time she'd thought, maybe I wasn't the problem. She cried in the interview. The journalist noted this in the piece without sensationalizing it. I reached out to Teresa Park directly after the article. We exchanged long emails. She told me things about Sandra's earlier years in the role, when she'd first consolidated power, when she'd first started using enforcement as a tool, that gave me a more complete picture of what I'd been dealing with. Sandra had been doing this for a long time. I was just the one who hadn't left. I also reached out to Lena Garcia. She was surprised I'd contacted her. She was cautious at first, then warmer. She said she'd like to meet. We met for coffee in late August, her, Eduardo, me, at a diner between our current homes. They were a quiet couple, mid-50s, with kind faces and a weariness that I recognized. We talked for nearly 2 hours. I told them everything. They listened. Eduardo said, "You know what we learned from this? You have to be willing to be the one who doesn't leave." I said I understood. He said, "No, I mean that literally. Somebody has to stay. Because if everybody goes, she wins every time." I thought about that all the way home. Late August brought two significant legal developments in the same week. On Tuesday, the AG's civil enforcement action was formally filed. Sandra Kowalski, personally, named as the respondent. On Thursday, the county prosecutor announced that a plea agreement had been reached on the criminal charges. Sandra would plead guilty to 1 count of identity fraud and 1 count of wire fraud, Class F felonies, with sentencing to follow. The plea agreement included restitution, to me specifically, for the fraudulent listing costs and associated damages and community service. It did not include jail time, which the plea allowed her to avoid on account of no prior criminal record. Her attorney called it acceptance of responsibility. The county prosecutor called it a resolution that holds a pattern of conduct accountable. I did not comment publicly. Sentencing was set for September 14th. I would be permitted to attend and to read my victim statement aloud if I chose to. I chose to. The week before sentencing, I was walking Walter in the evening, the same route I'd always taken, up Birchwood, around the court, back home, and I passed Sandra's house. The lights were on in the front room. Her car was in the driveway. The boxwood hedge was still perfectly trimmed. The flagpole stood with the flag at half-staff for some reason I didn't know. Nothing about the outside of that house showed what had been happening inside it for 7 years. That's the thing about people like Sandra. They maintain the appearance of everything being exactly right, until they can't. I thought about what I wanted to feel at sentencing. I'd been asked by a friend, a well-meaning friend, whether I wanted Sandra to go to prison. I thought about it honestly. What I wanted was for it to be real. For there to be a public record, in a court of law, that what Sandra had done was wrong. Not just inconvenient, not just a dispute, not just a misunderstanding, but wrong deliberately with calculation and malice. I wanted that to be written down somewhere she couldn't revise. The night before sentencing, Lily asked me to read her an extra chapter at bedtime. I did. She fell asleep with her hand on Walter's back. I sat in her room for a while in the dark. The garden was outside. My garden, my land, my strawberries pushing up runners in the late summer warmth. I thought about Sandra's log entry, Emchin unlikely to fight long-term. I thought about how long this had been. September 14th. The Millbrook County Courthouse, Room 4B, wood paneling, fluorescent lighting, the smell of floor cleaner. I arrived 30 minutes early with David Hargrove, who sat beside me. The Garcias were in the gallery. Teresa Park had driven from Columbus and was sitting 2 rows behind me. Frank was there. James Okafor was there. Maria was there. 11 neighbors altogether. The courtroom filled slowly. On the other side of the center aisle, Sandra sat with her attorney, the Columbus firm's man, a tall person named Barrett, who had the practiced stillness of someone very expensive. Sandra was dressed carefully. Navy blazer, pearl earrings, hair set. She did not look at me. The proceedings began with the formal entry of the plea. The judge, the Honorable Patricia Mallory, a woman in her 60s with wire-rimmed glasses and the air of someone who had seen a great many things and was not easily surprised, confirmed Sandra's acknowledgement of both counts. Sandra's voice, when she spoke her answers, was controlled and quiet. "Yes, Your Honor. Yes, Your Honor." Then the prosecutor presented the factual basis for the plea. He walked through the fraudulent listing, the IP address, the MLS submission, the false personal information. He walked through the identity fraud. He spoke clearly and without drama. The facts needed no embellishment. When he finished, the gallery was very still. David had prepared me for the victim statement portion. He told me to speak slowly, to address the judge and not Sandra, and to say what was true rather than what felt satisfying. I had practiced it twice. I had not cried during practice. Judge Mallory called for victim statements. I stood up. My hands were steady. I carried 2 copies of the 4-page statement, one for me, one I'd given to the clerk. I looked at the judge. I began. I described moving into the house 6 years ago. The raised beds, the irrigation, the stone path. 12 years of gardening knowledge brought to Ohio soil. I described the first violation notice 11 days into ownership. I described 27 notices over 6 years. I did not editorialize. I named specific dates and amounts. I described the survey, the fence, the morning I came home and found my yard on someone else's side of the cedar. I described my daughter asking where her strawberries were. My voice did not crack. I moved through it steadily, paragraph by paragraph. I described the community health log. I did not read Sandra's entry aloud. David had advised against quoting from an ongoing civil matter, but I referenced its existence and said, "This scheme was not a spontaneous lapse of judgment. It was planned, tracked, and updated 47 times over 6 years. I am documented in that record as unlikely to fight long-term. This assessment was wrong." I described the fraudulent listing my home, listed for sale without my knowledge or consent, at 2 a.m., at $67,000 below market, with a 30-day close deadline, while I was asleep with my daughter. I said, "This was not a violation notice or a procedural maneuver. This was an attempt to force me out of my home by manufacturing the appearance of a motivated seller. It was designed to undo 6 years of my life in 30 days. I said, I am still in my house. My garden is restored. My property line is correctly recorded. My daughter's strawberries are growing again. I tell you this not to minimize what happened, but because I think the court should understand that the intended outcome did not occur. And the reason it did not occur is that I had access to legal representation, professional surveying services, and the time and resources to fight. Many of Ms. Kowalski's other targets did not. They are documented in the Attorney General's findings. They left. This is the fuller picture of what we are accounting for today. I sat down. The courtroom was quiet. David put his hand briefly on my forearm. I did not look at Sandra. Barrett, Sandra's attorney, offered a statement on her behalf. He described her as a dedicated community servant who had, over time, allowed her sense of mission to cloud her judgment. He used the phrase meaningful accountability twice. He mentioned her clean prior record, her community contributions, the volunteer hours she'd given to Elm Grove. He was very good at his job. Then Sandra was permitted to speak. She stood. She was composed. She turned slightly toward the gallery and said, I want to take responsibility for actions that caused real harm to members of my community. She paused. I believed I was making Elm Grove better. I know now that belief was used to justify things that were wrong. She sat down. It was a good statement, measured, appropriately contrite, carefully worded. I listened to it and thought, she is still managing the presentation. She is still thinking about how she looks. And I thought that was not my problem anymore. Judge Mallory took a brief recess. When she returned, she delivered her sentencing remarks before announcing the sentence. I will try to describe them accurately because they mattered. She said, the crime before the court is identity fraud and wire fraud, to which you have pleaded guilty. But the record before the court, including the AG's civil enforcement findings, the victim statements, and the factual basis established at this hearing, tells a story that is larger than 2 counts of fraud. She paused, adjusting her glasses. She continued, what this record describes is a sustained, calculated campaign against a neighbor, using institutional authority as a vehicle. The fraudulent listing was the end point of a process that began years earlier, when you made a deliberate decision to treat your position of trust as a tool for your own interests. The victims of that campaign, some of whom you see in this gallery today, trusted the institution you represented. You exploited that trust. Systematically. She looked at Sandra steadily. You have expressed remorse today. I hope it is genuine. The sentence I am about to impose reflects both the terms of the plea agreement and this court's understanding of the harm you caused, including to people not directly named in these charges, whose stories are documented in the materials submitted to this court. Judge Mallory imposed 3 years of formal probation, with conditions including no contact with any Elm Grove HOA residents without their written consent, for 100 hours of community service, specifically to be served in housing counseling and tenant advocacy organizations, restitution as calculated by the prosecutor, and a formal prohibition from serving in any HOA board or governance role for a period of 10 years. She also said, and this was not required by the plea but was within her discretion, the court is making a formal recommendation to the Ohio Real Estate Commission that they review whether Ms. Kowalski's real estate license should remain active during the period of probation, given the nature of the fraud committed. Barrett's expression did not change, but something in his posture did. I hadn't known Sandra had a real estate license. I looked at David. He looked at me. He had a very small, very specific expression, the one he got when a fact aligned with something he'd suspected. Later, in the parking lot, David told me he'd confirmed it in the public records during discovery, but hadn't thought it central to the case. Sandra held an Ohio real estate salesperson's license under her married name and had, according to records, completed 7 transactions in the past 5 years. 3 of those transactions involved Elm Grove properties. He said, "The commission will have something to say about this. Reveal and punishment." 24 paragraphs. The commission inquiry began within 6 weeks of the sentencing. It moved deliberately, these things always do, but it moved. Meanwhile, the AG's civil enforcement action proceeded toward its own resolution, which I was not a party to but tracked through public filings. The AG's action resulted in a civil consent decree signed in October. Sandra agreed to pay $94,000 in civil penalties and disgorgement, representing the financial benefits she derived from the property scheme and the Green Line referral fees. She was also ordered to cooperate fully with any future civil claims by the 5 identified homeowner victims. The Garcias were first in line. Eduardo Garcia called me when the consent decree was signed. He was quiet on the phone for a moment and then said, "We're going to be okay." I said, "I know." He said, "Thank you for not leaving." I said, "Thank you for telling me your story." We agreed to have dinner when things settled. We did 2 months later. It was a good dinner. The civil case between me and Sandra personally, separate from the HOA settlement, concluded in November. Without her attorney's help with the criminal defense and with the weight of the established record, the personal civil case resolved at mediation. The terms were under NDA, but I will say that the appraisal figure of $22,000 to $31,000 was not the ceiling of what was resolved. The community health log, Sandra's private record of 31 Elm Grove residents, was the subject of a separate proceeding. The AG's office worked with the affected homeowners to notify them that they had been subjects of the log. Most of them were people I'd never spoken to. Some of them were people who'd left. All of them were offered resources and referrals for any civil remedies available to them. Deborah Holloway avoided criminal charges. The AG's office determined she had been complicit through negligence rather than intent. She did resign from the board formally in August and issued a written public apology to the Elm Grove community. She was, I believe, genuinely remorseful. I have not become close with her, but when I see her in the driveway, we nod. That feels like enough. Craig Simmons stayed on the board through the end of the year and then stepped down, saying he'd served his purpose. He was replaced through a proper member election, the first one Elm Grove had held in 8 years that wasn't effectively predetermined. 5 people ran. Thomas Webb won the most votes. Frank was elected to a board seat. He called me to tell me and sounded quietly delighted. The new board's first act was to commission an independent audit of the past 7 years of HOA finances. The audit took 3 months and found, in addition to everything the AG had already documented, approximately $28,000 in unauthorized expenditures that had never been properly voted on. The board filed a supplemental civil claim to recover those funds. That case was still pending at the end of the year. Rick from Greenline Solutions, Sandra's brother-in-law, agreed in a separate civil settlement with the HOA to reimburse a portion of the inflated contract amounts, citing his cooperation with the AG's investigation as a mitigating factor. He also agreed never to bid on HOA projects in Millbrook County again. His company continued operating in neighboring counties. The Ohio Real Estate Commission concluded its review of Sandra's license in January. It issued a formal consent order revoking her real estate salesperson's license for a period of 5 years, citing the fraudulent listing and the court's findings about her pattern of conduct involving property. The order was public record. Andrea Sloan covered it in a short piece in the Gazette. 700 people shared it online. I did not share it. I didn't comment. I had long since stopped tracking the social media response to any of this. What happened in public was the court's record and the AG's findings and the commission order. Those didn't need my amplification. They existed. They were real. That was what I'd wanted from the beginning. Sandra put her house on the market in February. The listing appeared in the MLS, a proper listing through a different agency, at a price that reflected the neighborhood's current values and the recently restored condition of the surrounding properties. My restored garden and the broader uptick in Elm Grove's reputation after the board changes had, according to Margaret Yee in a follow-up appraisal, added value to the whole street. Sandra's house would benefit from that. I found this deeply ironic and chose not to hold it against my garden. Her house sold in 41 days, just slightly above asking price. I know this because real estate sales are public record. The buyers were a couple in their 30s with a young child. I saw them during the inspection, carrying coffee, the child running ahead of them on the sidewalk, the same way Lily had when we first visited this house 6 years ago. I thought about going over to introduce myself. I thought about it for 3 days. Then I decided that whatever story they needed to write here was their own story, and I should let it start clean. I did put a welcome note in their mailbox the day they moved in. A simple one, with my name and number, offering to answer any questions they had about the neighborhood. The new woman, whose name I learned is Rachel, knocked on my door that Saturday to say thank you. She seems kind. Sandra moved to a condo in a suburb 40 minutes away, according to something Frank's wife mentioned having seen online. I don't know what her life looks like there. I don't need to. She's on probation. She's without her license. She's without her board seat and her flagpole and her Property Pride Award and her 7 consecutive terms and her clipboard and her Community Link admin access and her plaque on my fence. Whatever she is building in that condo, she is building it without the tools she used here, and that is enough. Lily's 10th birthday was in March. She asked for a garden party. Outside, in the yard, around the raised beds, with string lights and a cake shaped like a strawberry. I said yes to all of it. Frank helped hang the lights. Maria brought food. The Nguyen's brought their kids. Thomas and his husband came. Rachel from next door came with her daughter, who immediately became Lily's new best friend, which is the best possible outcome from all of this. We ate cake in the garden as the sun went down. The strawberry beds were heavy with new growth. They'd overwintered in pots and come back stronger for it. The string lights reflected in the wet leaves from a brief rain earlier in the afternoon. Walter ate a piece of cake off a paper plate that someone left too close to the ground. Nobody was upset about it. I stood at the edge of the yard for a moment, watching all of it. The kids running, the neighbors laughing, the lights, the garden, the evening, and I thought about the Tuesday morning 8 months before when I'd walked out and found the fence. I thought about the folder on my desktop. I thought about 41 pages of survey data and a log with my name updated 47 times and a fence plaque bolted to a post on my property and a little girl asking where her strawberries were. And I thought about the entry in Sandra's log, Emchin unlikely to fight long-term. And I thought, you were wrong about that. You were wrong about a lot of things, but you were especially wrong about that. By summer, Elm Grove looked and felt different. The new board had revised the CC and RS, through a proper member vote, to require independent verification of any contractor conflicts of interest, to mandate that all survey work be performed by a licensed firm before any boundary-adjacent construction, and to establish an ombudsman process for violation disputes. 43 of 47 households voted yes on the new CC and RS. The Community Link platform was replaced entirely with a new system, one with full homeowner access to their own records and an audit log showing who made what change and when. The enhanced monitoring designation was formally eliminated. The old data was archived rather than deleted, per the AG's requirements, but it was no longer active or visible in residents' profiles. The HOA hired an independent management company to handle day-to-day operations. No more self-administered board management, no more single person with full admin access to everything. Checks and balances built into the structure. It was not a perfect system, no HOA system is, but it was a real one. The 5 households the AG had identified as victims of the property scheme all received resources and support. 3 of them, including the Garcias, pursued civil remedies of their own. I did not join those cases, my recovery was separate and already concluded, but I provided affidavits supporting their claims because the right thing to do is usually not the easy one and usually not the convenient one and is sometimes just doing the paperwork anyway. My property value, per a final appraisal I had done in September, had returned to and slightly exceeded its market trajectory from before the dispute. The combination of restored land, corrected records, and the overall improvement in Elm Grove's HOA governance had an effect on every property on the street. Margaret Yee called it community-wide normalization in her report. Frank called it, we got our neighborhood back. I preferred Frank's phrasing. I never moved. I want to be clear about that because sometimes people assume, oh, she settled, she got her money, now she'll sell and move somewhere easier. I did not move. I am still at 14 Birchwood Court. I still pull into my garage in the evenings. I still water my garden on weekends. I still wave to Frank every morning. I am still here. There is a version of this story that ends with me bitter, with 6 years of harassment and an 8-month legal battle leaving a residue of distrust and exhaustion that colors everything after. I understand why that version exists. I was exhausted. I was angry for a long time. I paid for things I shouldn't have had to pay for, fought for things I should never have had to fight for, explained myself to agencies and boards and courts when the only explanation that was ever true was, this is my land. But bitterness requires you to keep carrying the thing that was done to you. I set it down. Not because Sandra deserved my peace, she didn't, and I am clear-eyed about what she is, but because Lily is 10 years old and she is going to watch how I live, and I want her to see that you can survive being calculated against, that you can fight without becoming the fight, that you can come out the other side still recognizable as yourself and still in your own house with your own strawberries growing in your own yard in your own soil under your own sky. On a Tuesday morning in October, almost exactly 1 year after I had walked out to find the fence, I stood at my kitchen window with my coffee and looked at the garden. The strawberries had gone dormant for the winter, mulched and tucked in. The raised beds were tidy. The irrigation was winterized. The sky was gray and ordinary and mine. Walter sat beside me. Lily was still asleep. The fence was gone. The plaque was gone. The damage was paid and recorded and closed. The case was over. The yard was quiet and it was mine, completely, and I drank my coffee and went to work.